Hey class, Mr. Stewart here. This is going to be the integrity video for week 6 here for the summer term. And today we're going to be talking about the criminal trial. And I'm going to apologize to you because this video is posted a little late this week. Been a hectic week. Had to have a day off. Take my son to the doctor, but just one of those weeks where things just didn't get done in time. But I apologize for that. One other thing is I also sent a message out to you guys, email out to you guys, and posted an announcement in the class in regard to a field trip opportunity that's out there on July 17th. We're going to visit Shiloh National Battlefield and the Sheriff Buford Pusser Museum. Cost to be about $5 plus a sack lunch, whatever sack lunch you want to bring. I think anybody wants to go, first come, first serve. I have some slots left. Make sure you let me know. Probably no later than about the 10th or the 11th of the month. So we got a few days here, but I think you'd enjoy that. Anybody wants to go? All right. Today or this week, you've been tasked with reading chapter 10, which has to do with the criminal trial. Now, I'm going to go through some of these slides in regard to the trial. This probably won't be a hugely long integrity video because it's pretty straightforward, and most of you that have watched any TV shows that kind of a criminal trial shows, legal shows, the trial works pretty much the way you see it does. I mean, there's not a whole lot of ways to file up how a trial works. The first thing I want to talk about, though, is prior to the trial beginning, or during the trial, is that criminal defendants have some basic protections under the law. Now this slide says, and hopefully you can see the slide and you can hear me and see the slide, it says identify the basic protections enjoyed by criminal defendants. It doesn't mean they like them, it just means this is what we give you. Because you have been charged with a criminal offense, then we're going to make sure that we protect your rights by allowing you to have certain protections under the law. Because think about it this way, if we didn't protect the criminal's rights, how long would it be before we began to also erode the rights of the non-criminals? So the fact that somebody's charged with a crime doesn't mean that their rights are going to be violated on purpose. It means that we're going to take some extra steps to make sure that their rights are protected up to the point of conviction, and then we're going to punish you. Because what we don't want to have happen is somebody gets convicted and then gets off on some sort of technicality because we violated a right or something like that. So keep that in mind. The first is the right to a speedy trial. Now this is interesting because most people laugh when they say speedy trial because it seems like it takes forever for some cases to go to trial. The simpler the case, the quicker it goes to trial. The more complex the case it is, the more things that have to happen before a trial can actually begin. You get somebody charged with a DUI, you're going to go to trial typically within 6 months. And why does it even take that long? Well, if you've sent a blood sample to the state crime lab for a blood alcohol content level to be, test to be performed, then it may take a while to get that back. It may take a while for the judge, your attorney, and the prosecutor to get all their schedules together, and then you go kind of after other trials that have already been scheduled. So, you're looking at anywhere 6 months or less, probably for a DUI, would be considered a speedy trial. And it's not necessarily the time period is what makes a speedy trial, but it is there anything happening with your case? If there's still something happening with your case, but you have not yet gone to trial, it could honestly go on for an indefinite period of time and still not violate your Sixth Amendment right to a speedy trial, as long as there's something happening with the case. The whole reason we have a speedy trial is to keep people from languishing away in jail for long periods of time, and then before we ever decide to take them to trial, using the pre-trial detention as punishment, if you will. Now, there are some countries that do this. Mexico, for example, if you get arrested today, they may keep you in jail for 3 or 4 years before they ever decide to have your trial. And then they have your trial and not invite you to it, and then come and tell you that you were found guilty and and you received a 5-year sentence in addition to the time you've already served. So, when you look at our system in light of some of the other systems closer to us, we still have a really excellent criminal justice system. Now, also, again, I said the more complex the case, like a murder case, would take a lot longer to go to trial because there's more preparation that would need to be done in order to provide an adequate defense, because you are entitled to an adequate and zealous defense if you're a criminal defendant, and it also allows the prosecution time to prepare their case as well, and to go through any pretrial motions or anything prior to the time that the trial can actually begin. Understand that all 50 states have some sort of speedy trial statute, and a good rule of thumb, especially at the federal level, is about 72 days or so from the time of arrest that you're going to go to trial, unless it's a highly complex case, and it's probably going to be given several continuances past that 70-day time period. Another right is the jury. You have a right to a jury trial, and you have a right to have an impartial jury made up of your peers. Now, that doesn't mean that if you're from Puerto Rico and you come to Huntsville and you commit a crime, that we're going to have to go to Puerto Rico and find a jury of your peers there. What your peers consist of is a cross-section of the population of the area in which the crime was committed. And we have to take some steps to make sure that jury is as impartial as it can be by asking them questions, and hopefully that they're truthful with us in the answers to those questions during jury selection, to make sure that they can objectively hear the facts of the case and make a decision in regard to those. Juries in most states also require unanimous verdict for criminal cases. And that means if you've got 12 jurors on the jury, all 12 must agree to convict, or all 12 must agree to acquit, find you not guilty. If you have a hung jury, that means that it's not a unanimous verdict. The judge can, and in most cases will, suggest to the jury that they continue working until they reach a unanimous verdict. If the jury comes back and says, we're hopelessly deadlocked, we cannot reach a unanimous verdict, then what will happen is the judge has no choice but to declare a mistrial. And because no verdict has been rendered, the prosecution can try you again for that case because there's not been a verdict issued. So just understand that the jury has to be unanimous. The Fifth Amendment. This is the privilege against self-incrimination. And what this means is that if you are a criminal defendant, you are not required to testify on your own behalf, and that choice of not testifying on your own behalf shall not be used by the jury as an indication of your guilt. It shouldn't prejudice them. This means that, most people who are criminal defendants, they want to get up there and they want to tell their side of the story. The problem with that is, if you get up there and you tell your side of the story, you open yourself up to be cross-examined by the prosecution. And if that is the case, they will try their best to poke holes in your story, to find inconsistencies in your previous testimony, or outright show that you lied on the stand. In which case, that can destroy your credibility with the jury, and may then prejudice the jury. So that's why most defense attorneys suggest that their clients do not testify on their own behalf. Let's use other witnesses to tell this defendant's story instead of the defendant themselves, because they don't want their client open to that cross-examination. So what are some of the requirements typically imposed on jurors? I already talked about what a jury of your peers was, but you also have to meet some other basic requirements. Typically, you have to be a citizen of the United States. We don't want somebody who is an illegal alien serving on a jury to convict a citizen. You have to be at least 18. You can't have any felony convictions yourself. You have to be of the necessary physical and mental good health to serve, which means physically you got to be able to see the evidence, hear the testimony, and mentally you have to be able to process the information and make an objective decision. So therefore, we typically don't choose seriously handicapped persons or cognitively challenged people to serve on a jury, because it just wouldn't be fair to the defendant. You also have to be sufficiently intelligent to understand the issues in the trial. And I don't really know how we can assess that, because we don't give jurors an IQ test, but I guess if you talk to somebody, ask them a few questions, and they can develop a coherent response answer to your question, then we would consider that they're sufficiently intelligent to serve on a jury. You also have to be able to read, write, and comprehend English, because right now in this country we do conduct trials in English. That may change in the future, but right now we still do it in English, and so therefore the jurors need to be able to read and write, comprehend English themselves, so that they can understand the evidence that is presented and make a decision based on it. Once we have developed a pool of jurors, and this is a pool of jurors is called a veneer, V-E-N-I-R-E, veneer. This veneer is pulled from voter registration lists, vehicle registration lists, property tax list databases, and then you're called to jury service, and then they begin to impanel you and ask you a series of questions to make sure that you can objectively hear the evidence and make an unbiased decision based solely on the evidence at hand. That also that you're not biased against the defendant, biased against the prosecution, or a particular punishment or whatnot. That's why we call a whole bunch of potential jurors in to seat a panel of 12 and 2 alternates in most cases. This is one of those things that I have seen cases where we called 150 potential jurors in, and we still had a hard time seating 12 jurors and 2 alternates, because it was a high-profile case. People knew about it. People were familiar with the defendant, or familiar with somebody that was involved, or they were they had some predispositions in regard to the case. Now, this questioning of the jurors is called voir dire, and it simply means to question or to ask. And typically during this questioning process, the attorneys, each side, the prosecution and the defense, have the ability to throw out an unlimited number of potential jurors who could be biased. And this is called a challenge for cause. This is when the attorney provides a sound, legally justifiable reason why a potential juror should not or cannot serve on the jury. If you know the defendant, you know the prosecutor, you have a conflict of interest, or you're a convicted felon, or whatever, each side gets an unlimited number of these challenges for cause. And they do have to provide a reason why that person is challenged. And then it's up to the judge to agree with that reason and then exclude that juror. Also understand that both sides have the ability to release a limited number of potential jurors from service on a peremptory challenge. And that simply means that they might not like the way you dressed, they might not like the way you talked, or they don't like the car you drove up in, or they don't like your demeanor. They don't actually have to say any of that. They can just say, I just want this person gone. I don't want them to serve on the jury. And you can understand that why there will be a limited number of those. And most states allow for about 3 potential jurors on each side to be excluded on a peremptory challenge, because if we had an unlimited number of those, then we'd never get a jury seated. We'd never find a jury that was acceptable to both sides. But through this process of voir dire and challenges for cause and peremptory challenges, for the most part, we're able to seat an impartial jury of the defendant's peers who can objectively look at the evidence and make a decision. After the jurors are seated, that's when we actually begin the trial. And you can read through this section in your book. I'm not going to go deep into the actual steps of the trial because it's straightforward. It makes sense. You know, both sides present their case. They present their evidence, their witnesses, using a prescribed procedure so that the rights of all are protected. And then once the case is concluded, then the jury gets to deliberate and make a decision. Just understand that how the jury decides is probably going to be based on which side, the prosecution or the defense, that they have found to be the most credible. Because you're going to have the prosecution saying one thing, you're going to have the defense saying, in most cases, something completely opposite. So it's going to be, do they trust the prosecuting attorney more than the defense attorney? Do they like them more? Were the witnesses for the prosecution better than the witnesses, more credible than the witnesses for the defense, or vice versa? And whichever side had the most credibility and the most compelling evidence is typically how that jury is going to decide if they are doing it the way they're supposed to. Unfortunately, we do have juries sometimes that figure the police got it right. This is a necessary step, but we've already made our decision. You know, we want our pound of flesh out of this defendant, and so therefore they must get convicted. All right. Next couple slides, and you can read about this in your text as well. It talks about the different types of evidence and witnesses. Please read over that. It's also very straightforward. It's not very hard to comprehend. It also talks about the defenses that are used, such as and the strategies that are used for defense in regard to, typically once the prosecution gets to present their case first. Why? Because they have the burden of proof. The prosecution must prove you guilty beyond a reasonable doubt. The defense actually has no burden of proof whatsoever. All they really should do to provide an adequate, zealous defense is to try to put doubt in the minds of the jury. If the prosecution has done a crappy job of presenting evidence, they may not even have to do that. And so in many cases, what the defense will ask after the prosecution has rested their case is they will ask for a motion for a directed verdict, or they will make a motion for a directed verdict. And that is basically telling the judge, saying, Judge, they have not proved their case beyond a reasonable doubt, so I'm asking for a dismissal right here, right now, before we even have to present anything. And it's very rare that a judge will grant that motion for a directed verdict, but it does happen on occasion. So typically that doesn't work, and so then it's up to the defense strategy to create a reasonable doubt in the minds of the jury. They're trying to put that little inkling of doubt in the mind of the jury that this defendant did not engage in this crime. Or, if they can't do that, they'll present an alibi. They'll say, my client could not have engaged in this crime because he was with somebody else doing something different in a different location. And so if the jury buys into that, they don't have a choice but to find that defendant not guilty. And in other cases, the defense strategy is to present an affirmative defense. And basically that means they're not saying the client didn't engage in the act. They're saying they did it, but here's why. And here's why you should not hold them criminally responsible for it. Such as if it was in self-defense, or if it was due to insanity, or they were under duress, or maybe they were entrapped by the government. Entrapment doesn't usually work. Duress has not had a huge success rate. Insanity TV likes you to believe that the insanity defense is very common. It actually only is tried in about 10% of cases, and it's probably only successful in about 1% of all the cases it's tried in. It's very rarely a successful defense. And then, of course, you get self-defense. That one's kind of toss up as to whether the jury's going to buy into that or not. This learning objective asks us to think about double jeopardy for a moment. Understand that if that double jeopardy does not apply if the jury cannot reach a verdict, which means if they have a hung jury and it results in a mistrial, that defendant can be tried again. And if they continue to receive mistrials on behalf of the jury, hung juries, you can be tried an indefinite amount of times. If the defendant is found not guilty, there is no grounds for an appeal. The prosecution cannot appeal an acquittal. However, the defense does have the ability to appeal a conviction. And if the judge grants an appeal, basically the judge can say, yeah, I've looked at this, and I'm going to grant your appeal because errors were made at trial, and because errors were made at trial, the jury would have likely reached a different verdict if those errors had not been made. So we're going to remand you back to the lower court, and you're going to be retried. So basically they will set aside the conviction as if it didn't happen, and then that allows for a retrial. Double jeopardy does not kick in at that point. However, if the error was so fatal to the case, the judge could simply say, this case is dismissed and this inmate or this defendant is freed, pardon me, and you're not being retried. They can do that too. Or the judge can say, no, there's no grounds for this appeal, you're still convicted. And then, of course, that doesn't preclude you from filing more appeals. It just basically says you didn't get this one. And then this last learning objective goes into the 5 basic steps of an appeal. Just understand that the appeal is not based on the facts of the case. It is only based on errors committed at trial, and were those errors sufficiently severe that if they had not happened, would the jury have likely reached a different verdict. And so it's up to typically an appellate court judge to look at the documentation that's been provided to make a decision whether that appeal should be granted or not. Alright, that's all I'm going to cover today. That kind of gives you the criminal trial process in a nutshell. If you have questions, problems, or concerns, please reach out. Text me, email me, or whatnot, and I'll see you in discussions. Have a good week. Bye-bye.